Hello students, this is Jonathan Lipson with The Real Deal on Contracts. Today we're going to talk about unconscionability. If you are in my class, this corresponds to units 29 and 30. We'll talk about three things. Number one, what is unconscionability doctrine and how does it relate to other doctrines that you've already seen? Number two, we'll talk about how unconscionability is related to the use of arbitration clauses in business-to-consumer contracts. And number three, we'll talk about the current trend in the use of unconscionability doctrine by public officials to try to police the misuse of certain kinds of business-to-consumer contracts. So number one, unconscionability doctrine. Unconscionability exists as a doctrine both at common law and under the UCC. 2302 of the UCC, I think, is a common or commonly looked to articulation of it. It says that if the court, as a matter of law, finds a contract or any clause of a contract to have been unconscionable at the time it was made, the court may refuse to enforce the contract, or it may enforce the remainder of the contract without the unconscionable clause, or it may so limit the application of any unconscionable clause as to avoid any unconscionable result. That is a lot of unconscionables. And so your question might naturally be, well, what does that mean? It turns out we don't know exactly what it means. Comment 1 to 2302 says, the basic test is whether, in the light of general commercial background and the commercial needs of a particular trade or case, the clauses involved are so one-sided as to be unconscionable under the circumstances existing at the time of the making of the contract. The principle is one of the prevention of oppression and unfair surprise. Fine, okay, so something about a significant imbalance of bargaining power, something about oppression, something about unfair surprise. I guess ordinary surprise is okay, unfair surprise not okay. The first major case to deal with unconscionability, as articulated by the UCC, is Williams v. Walker Thomas Furniture. We'll spend a fair amount of time on the case, but it has set forth what has come to be known as, or thought of as, a two-part test, one element being procedural, the second element being substantive. So the DC Circuit says, or the U.S. Court of Appeals in DC says, unconscionability has generally been recognized to include an absence of meaningful choice on the part of one of the parties, that's the procedural element, together with contract terms which are unreasonably favorable to the other party, sort of the substantive element. Did each party to the contract, the court suggests we need to ask, considering that party's obvious education or lack of it, have a reasonable opportunity to understand the terms of the contract? Or were important terms hidden in a maze of fine print, and so on? You should almost instantly ask yourself, well, how can we reconcile this with everything we've learned in cases like McCutcheon v. McBrain and Pro CD and Hill and so on and so forth, all of which say that, if you have signed it, you are bound by it, even if you did not understand it. They're obviously in tension. And I think that part of what you see in both the case law on unconscionability and the literature about it is, evidence of that tension. In terms of remedy for a finding of unconscionability, the statute suggests courts have pretty open field. So it specifically seems to contemplate a kind of blue penciling. We saw that in Fullerton Lumber. Court can rewrite the unconscionable portions to make them, I guess, conscionable. Then the question then arises, are affirmative recoveries available? Can a plaintiff actually get money for having agreed to enter into a clause that turns out to be unconscionable? Not surprisingly, the tensions that we see here have led to a variety of challenges to the use of unconscionability. Efficiency, of course, is a classic argument against unconscionability doctrine. Richard Epstein, I think, has a nice quote, sort of explaining why unconscionability challenges might produce, inefficiencies in the business-to-consumer market. Arthur Leff, famous law professor from Yale, says, by the way, like, it's totally ambiguous, this unconscionability thing. We have no idea what it means. It's invited judges to rely on their own emotional state, he says. And of course, there's an issue of institutional choice. Leff said, really, these are problems of policy and politics, and they should be left to legislatures, not to judges. And there's certainly something to be said for that. But, when courts are faced with cases that they feel are really bad and really hard, they nevertheless want to do something. So courts are sort of caught up in this tension. Comparison to other doctrines. Unconscionability looks like, but is different from things like incapacity, fraud, and duress. As you can imagine, there are important ways to distinguish them, even though they overlap. Capacity, for example, as we've seen in cases involving intoxication and, mental illness, really involves an individualized inquiry, whereas with unconscionability, we're looking at the social or socially induced deprivation of some kind of capacity, for example, education. Fraud looks like it might be similar, but of course in fraud you have material misrepresentations and an intent to deceive, and you don't necessarily have to find either of those in unconscionability. There was nothing hidden about the terms in the Williams v. Walker Williams v. Walker Thomas contract. And duress, right? There's obviously something like duress going on here because you have this power imbalance. But duress also includes a threat to do something wrongful or unlawful, and that is not necessarily the case in unconscionability. All right, so that's the kind of basic background on the doctrine. Now let's connect it to arbitration and problems of collective litigation. As we've said before, there's a very strong policy towards promoting the use of arbitration. Arbitration happens principally if there's a clause in a contract in which parties have agreed to arbitrate. And what this really means is that they are agreeing to contract out of the use of the legal system. That could mean a lot of different things, but functionally what it means is that rather than getting to go to court, right, for example, as you saw in Hill v. Gateway, the Hills had to go to a private arbitrator who resolves their dispute in private. No published opinions, and it's not even clear what law governs or how arbitrators should operate. Historically, the Federal Arbitration Act, which governs arbitration clauses, was, I think, intended to be used in business-to-business contracts, not business-to-consumer contracts. But today, they're very frequently used in business-to-consumer contracts, and they are pretty powerful, and they're enforceable. The Federal Arbitration Act says that a written provision in any contract evidencing a transaction involving commerce to settle by arbitration a controversy thereafter arising out of such contract shall be valid, irrevocable, and enforceable, save upon such grounds as exist at law or in equity for the revocation of any contract. It's federal law, so that means it governs, it displaces, preempts any competing state law. But the first thing you should ask yourself is, well, what does this word revocation mean? It's not really something we've talked about. We talked about rescission. That's a concept that exists at state law. The common law of contract says that you can rescind contracts for things like fraud and so on and so forth. But it's not really clear what revocation means. Presumably it means something like rescission, although I don't think that the case law has been as clear as we might like. Unconscionability is important because that's been the classic way that consumer lawyers have challenged the use of arbitration clauses. And so then the question becomes, well, how does the Federal Arbitration Act interact with unconscionability doctrine, for example, as it exists under the UCC or Williams v. Walker Thomas and so on. And the short answer is that the Supreme Court has very, very, very aggressively and expansively interpreted the FAA. So, for example, the Federal Arbitration Act preempts state law unconscionability challenges. In other words, whatever unconscionability might mean under the UCC or cases interpreting state unconscionability doctrine are not really what govern here. Right, the AT&T mobility case says that there's some kind of federal law that courts are supposed to find and apply. Right, it's preempted by that state law is preempted by federal law. The Federal Arbitration Act may also preempt conflicting federal statutory law, such as like the National Labor Relations Act, which is what was an issue in the Epic case. Moreover, arbitrators themselves, not courts, are the ones who get to decide whether the arbitration clause itself is unconscionable, which, if you think about it, might present a problem. And I think the fourth thing about collective litigation and arbitration and unconscionability is that arbitration clauses typically include something known as a class action waiver, which is a provision that simply says, I agree that not only will I arbitrate my dispute, but I will not join any other class or aggregate litigation. And it's important, it's worth spending a moment thinking about, well, why is this important in this context? The third and final thing to talk about is the sort of the resurrection of unconscionability doctrine in its modern form through public enforcement or public policing of business-to-consumer contracts by either state attorneys general or even the federal government in certain circumstances. This often, at the state level, takes the form of what are known as UDAP statutes, statutes that prohibit unfair, deceptive, and abusive acts and practices. For example, this is the statute that is an issue in the BNB investment case. It does what it sort of suggests the name is telling you. Unconscionability ends up being, I think, a way that that gets woven into those elements: unfair, deceptive, and abusive. The federal government has gotten into the act a little more recently through the Dodd-Frank amendments of 2010, enacted in the wake of the financial crisis. Those created the Consumer Financial Protection Bureau, and the CFPB has pretty broad powers to regulate unfair, deceptive, and abusive practices as well. Dodd-Frank provides, some insight as to what those terms mean, which we can talk about in class. But an open question about both the state level enforcement of UDAP statutes and the federal government's own UDAP statute under the Dodd-Frank amendments is who can enforce? If it's just a public enforcement mechanism, for example, the state attorney general and BNB investments, that's one thing. If there's a private cause of action, obviously that's quite different, or that's another thing. At this point, I think the assumption is that there is not a private cause of action, at least at the federal level, but that is something worth thinking about. We'll discuss all of this more in class. In the meantime, that is The Real Deal on unconscionability.